Hello students, I am Priti, Assistant Professor, IIMT College of Law, Greater Noida. Today I am going to discuss on the topic of Article 12 of the Constitution of India, and we are here to discuss on this article. Article 12, which is the most important article and also the part of the fundamental right. Fundamental right, it starts from the Article 12 to Article 32. And in this, we discuss introduction, definition, essentials, scope and purpose of the state, doctrine of instrumentality, and some important case laws relating to Article 12. And we also discuss whether state includes judiciary or not, and whether the state itself can claim or enforce a fundamental right. So firstly, I introduce the topic that Article 12 is the part of Part 3rd of the Indian Constitution, and Part 3rd includes from Article 12 to 35 of the Indian Constitution, and it contains a long list of fundamental rights and protect rights and freedom to all. They also provide safeguard to minorities, protecting religious freedom and cultural rights. The basic aim of having a declaration of fundamental right is that certain elementary rights such as right to life, and personal liberty, freedom of speech, freedom of faith, etc., shall be regarded as inviolable under all conditions during emergency. However, some curtailment of the fundamental rights does take place. Since fundamental rights provide for the security of citizens' set of rights in relation with speech, expression, religion, against exploitation, education, language, culture, and constitutional remedies also. So these rights are not violated by the state, and the part third says that what is the meaning of a state. So we discussed that the term state has been used in this part in wider context to include all such agencies, actions of whose can be challenged in the court if they violate any of the fundamental right. So in introduction, we relate how the state comes in the purview. So next, the definition given in the Constitution, the definition of states under Article 12. So the definition of a state is given in Article 12 of the Indian Constitution is as follows. In this part means part 3rd of the Indian Constitution. Unless the context otherwise requires, meaning thereby if otherwise requires, behind that, unless the context otherwise requires, the state includes the government and Parliament of India, the government and legislature of each of these states, all local or other authorities within the territory of India or under the control of the government of India. So most of the fundamental rights are claimed against the state and its instrumentalities, and not against private bodies. According to Article 12, the term state includes, as discussed above, the government and Parliament of India, that is executive and legislature of the Union, the government and the legislature of each state, that is executive and legislature of the states, all local and other authorities within the territory of India, and all local and other authorities under the control of central government. So the definition of Article 12 cover all these essentials. So next we discuss essentials. The first two categories, that is the Parliament, that is executive and legislature of the Union, and the government and legislature of a state are self-explanatory. They doesn't need any explanation for these. And the next categories are discussed under the heading of essentials. So it includes, the word includes indicates that the definition is not exhaustive. Hence, even though The definition expressly mentions only the government and legislature. There might be other instrumentalities of state action within the sweep of the definition. The non-mention of the judiciary does not indicate that the courts are intended to be excluded from the definition. Authority means a person or body exercising power or having a legal right to command and be obeyed. An authority is a group of persons with official responsibility for a particular area of activity and having a moral or legal right or ability to control others. Authority means a public administrative agency or corporation having quasi-governmental powers and authorized to administer revenue producing public enterprise. Authority in law belongs to the province of power. Authority in administrative law is a body having jurisdiction in certain matters of a public nature. A government carrying on commercial activities incorporated under the Companies Act, which does not have any power of making rules or regulations binding as law, or the power to administer or enforce such rules or regulations, is not an authority under this article. The word authority includes central or state government. It also includes all constitutional or statutory authorities on whom powers are conferred by law, including even autonomous bodies, or and whether or not they are under the control of the government or whether or not they may be regarded as agents or delegates. The state also includes following bodies on the principle that if the body has the power of making subordinate legislation or statutory orders with the power to compel obedience to them, it would be an authority under Article 12. So this means all about the authority. The object of including all authorities within the term state in this part is to enlarge the scope of fundamental rights, which shall thus be binding upon every authority in India has the power to make laws, bylaws, etc., or the power to enforce them. But the widening of the scope of the word state also widens the number of authorities who are entitled to impose limitation upon the fundamental rights. Next, we discuss local authorities. Local authorities within the territory of India means an authority legally entitled to or entrusted by the government with the control or management of a local fund. A local authority is defined in Section 3, Clause 31 of the General Clauses Act 10 of 1897. The authority concerned must have separate legal existence as a corporate body. It must not be a mere government agency but must be legally an independent entity. It must be a function in a defined area and must ordinarily, wholly or partly, directly or indirectly, be elected by the inhabitants of that area. It must also enjoy a certain degree of autonomy, either complete or partial, must be entrusted by statute with the governmental functions and duties as are usually entrusted to municipal bodies, such as those connected with providing amenities to the inhabitants of the locality, like health and education, water and sewage, town planning and development routes, etc. Finally, such a body must have the power to raise funds for furtherance of its activities and fulfillment of its objectives by levying taxes, rates, charges, or fees. So that is all about the essentials. Next, we discuss the scope and purpose of state. John Law says that the purpose of state is common good or good of mankind. A state is a body that which comes into existence for maintaining the life, and upholds the dignity of its individual. Its purpose is to maintain the dignity and lifestyle of its individuals by holding their rights. Individual cannot have rights if state fail in its function. So that the framers of the constitution wanted to create a society in which all its citizens shall acquire all the basic fundamental rights. Thus, it became a duty on a state to enforce all the fundamental rights to the citizens so that they could overcome the oppression casted upon them in British. Individuals need constitution protection against states. The right provided in Part 3 of the Constitution are guaranteed against the state and distinguished from violation of rights by private. Private actions are protected by the sufficient laws. Majority of fundamental rights are enforceable against state only. Supreme Court observed that the object of Part 3 is to provide protection to the right and freedom guaranteed under this part by the invasion of state. Part 3 and Part 4 carry a theme of human right, dignity of individual and also of the unity and dignity of nation. These parts respectively act as a negative obligation of the state and that is not interfere with the liberty of individual and positive obligation of the state, which is to take steps for the welfare of the individual. Next, we'll discuss the doctrine of instrumentality, which is the most important doctrine of Article 12. This doctrine says the ambiguities laid to the establishment with contradicting interpretation were given a kind of stability with the evolution, the doctrine, so as to provide a better interpretation. Therefore, to provide the clear and liberal interpretation, the Supreme Court in the case of R.D. Shetty, Raman Dayaram Shetty versus International Airport Authority of India, held that if a body is an agency or instrumentality of the government, it may be an authority in Article 12. The court also laid down few of the tests which can test that the authority can fall within the limit of authority in Article 12 of the Constitution. These tests are as follows. If the entire share capital of the corporation is held by the government, it would go a long way towards indicating that the corporation is an instrumentality or agency of the government, meaning thereby the entire share capital of the corporation held by the government, then it will be a agency or instrumentality of government. Next is the existence of deep and pervasive state control may afford an indication that the corporation is a state agency or instrumentality. If there is state control, deep or pervasive, maybe. If there is state control, then the corporation will be a state agency or instrumentality. It may also be a relevant factor that whether the corporation enjoys monopoly status, which is state conferred or state protected. Next, if the functions of the corporation are of public importance and closely related to governmental functions, it would be a relevant factor in classifying the corporation as an instrumentality or agency of government. The next is specifically if a department of government is transferred to a corporation, it would be a strong factor supportive of this inference of the corporation being an instrumentality or agency of government. However, court said that these tests are not conclusive but illustrative only and will have to be used with care and caution. So the above given tests are not conclusive, they are just illustrative and they will be used with care and caution. Next, we will discuss some important case laws relating to Article 12. And in this regard, first we discuss the state of the Rajasthan State Electricity Board versus Mohanlal. In this case, the Supreme Court ruled that a state electricity board set up by a statute having some commercial functions to discharge would be an authority under Article 12. The court emphasized that it is not material that some of the powers conferred on the concerned authority are of commercial nature. This is because under Article 298, the government is empowered to carry on any trade or commerce. Thus, the court observed the circumstances that the board under the Electricity Supply Act is required to carry on some activities of the nature of trade or commerce does not therefore give any indication that the board must be excluded. The scope of the word state is used in Article 12. The next case we discuss is Sukhdev Singh versus Bhagat Ram. In this case, the Supreme Court, following the test laid down in Electricity Board Rajasthan's case by 4:1 majority, and held that Oil and Natural Gas Commission, Life Insurance Corporation, and Industrial Finance Corporation are authorities within the meaning of Article 12 of the Constitution. Therefore, they are state. All three statutory corporations having the power to make regulation under the statute for regulating condition of service of their employees. The rules and regulations framed by the above bodies have the force of law. The term of contract with a particular employer is prescribed by the statute itself. These regulations are binding on these bodies. The employees of these statutory bodies have a statutory status, and they are entitled to declaration of being an employment when their dismissal or removal is in contravention of statutory provision. The employees are entitled to claim under Article 14 and 16 against the corporation. In this sequence, the next case we are discussing is Raman Dayaram Shetty versus International Airport Authority of India. In this case, Justice Bhagwati preferred the broader test as suggested by the Justice Matthew in Sukhdev Singh versus Bhagat Ram. In this case, the court held that if a body is an agency or instrumentality of government, it may be an authority within the meaning of Article 12, whether it is a statutory corporation, a government company, or even a registered society. Accordingly, it was held that the International Airport Authority, which had been created by the Act of Parliament, was the state within the meaning of Article 12. The central government had power to appointment of any member from the board. The capital needed by it was provided only by the central government. But what is the test? Whether a body is an agency or instrumentality? The court laid down the following test for determining whether a body is an agency or instrumentality of the government. In this case, we discussed under the heading of scope, and here we are discussing in detail. The body can be called as state if its entire share capital is held by the government of India. Such other authorities have a governmental functional character. The absolute control of such authorities lie within the government. Such authorities which have an element of command or authority. The authority discharging public service. So this is all about the R.D. Shetty case. The next is Ajay Hasia versus Khalid Mujib. It has been held that a society registered under the Societies Registration Act 1898 is an agency or instrumentality of the state, and hence a state within the ambit of Article 12. Its composition is determined by the representative of the government. The expenses of society are entirely provided by the central government. The rules made by the society require prior approval of the state and is completely controlled by the government. The government has the power to appoint and remove the members of the society. Thus, the state and the central government have full control of the working of the society. In view of these elements, the society is an instrumentality of the state or the central government, and it is therefore an authority within the meaning of Article 12 of the Indian Constitution. Further, in this sequence, the next case is S.C. Chandra versus State of Jharkhand. In this case, the question arose for decision was whether the teachers of a school not owned by BCCL and was run by managing committee and whose teachers were never appointed by BCCL. Although BCCL used to release non-recurring grants subject to certain conditions, would result in such teachers to be considered as an employees of BCCL and entitled to all benefits available to the regular employees of BCCL. So in this case, the Supreme Court judgment was a common one and involved, amongst others, Bharat Cooking Coal Limited. Without any discussion, the court approved the view taken by the division bench of the Jharkhand High Court that BCCL was not an instrumentality of the state. As per section 617 of the Companies Act, as its dominant function was to raise coal and sale, and imparting education was not its dominant function. So this is all about the discussion about the cases which deals with the Article 12. Next, the very important aspect of this article is that whether state includes judiciary, whether the word state includes judiciary. For this, the judiciary, it is said, though not expressly mentioned in Article 12, it should be included within the expression of other authorities, since courts are set up by statute and exercise power conferred by law. Judiciary in India to be included under the ambit of state arose in the case of Naresh versus State of Maharashtra, which observed that while exercising the rule-making powers of judiciary is covered by the expression state with Article 12, but while performing its judicial functions, it is not so included. Thereby, a court may be sued for a violation of the fundamental rights to the extent only till it is performing its administrative function. The point it began its judicial function, it does not violate any fundamental right and cannot be taken as state. Whether the state itself claim or enforce a fundamental right? The answer of this question is given in the state of West Bengal by the Union of India, by the Supreme Court. For the majority, set forth a proposition under the Indian Constitution, fundamental rights may be claimed not only by individuals and corporations, but sometimes also by the state. His Lordship was obliged to assert this proposition as government by making compulsory acquisition under Article 31 Clause 2 gives rise to a right to compensation in favor of the expropriate owner, which should logically belong to the state when when property belonging to it is compulsorily acquired by the union. The observation does not deal the observation does not deal with the question whether, according to juristic principles, a fundamental right is intended for protection of right individuals or for the state as well, and that a corporation can claim some of the fundamental rights do not warrant the extension of that principle to the state. The proposition that fundamental rights were intended for the state as well runs counter to the basic philosophy and history of the Constitution against the exercise of arbitrary government authority. There was no question of protecting one limb of same federal state against another. This can be possible only if there is an express provision to that effect, such as Article 131, and the condition of that article are satisfied. But the enforcement of fundamental rights would not be covered by any of these exceptions to Article 131. Hence, union or state government cannot sue each other for violation of their supposed fundamental rights. So, students, this is all about the Article 12 of the Indian Constitution, which is very important part of fundamental rights, and fundamental rights will be clear if there is if if the definition of the state is clear to you. So thank you very much.